and welcome to this YouTube channel, Law with Charlie. I am Charlie Medcalf and I'm a Law LLB student at the University of Leicester. And welcome to this first lecture in the public lecture series, I Don't Want to Go to Prison, Terrorism Law and Proscribed Organisations. So firstly, what is the public lecture series? The public lecture series is a series of lectures which I plan to do, and it's about breaking the law down into easily digestible chunks and to try and make it as simple and accessible as possible, so people without a legal background can really start to appreciate the law, understand the law, know what the law is. That's because I am a firm believer that if we're going to follow the laws, we need to know what the laws are, and so the public need to be educated on what the laws are. And so this presentation is largely focused around terrorism law and proscribed organisations, and this is very much in response to the Palestine Israel protests and how the Palestine Action group has recently been proscribed in the United Kingdom. And somebody came up to me asking me a question: if they were going to protest about Palestine, would they go to prison? Their words were, "I don't want to go to prison." And so this presentation is centered around that area of discussion. What is the law, and how likely is it that you'll go to prison for protesting about Palestine or protesting about any issue where there's been a proscribed organisation? So before we go any further, this is probably the most important slide of this whole presentation now. That's this disclaimer. So I must make it really clear that this lecture is for educational purposes only, and it can only be taken as such. None of the contents of this lecture constitutes legal advice, and so you cannot take it as such. And if you are worried about this area of law or need legal advice, let's say you got arrested for associating with a proscribed organisation, or you are charged with a offence under the terrorism legislation, then you must go to a fully qualified and licensed legal professional. At the first instance, this would most likely be a solicitor, but you might also want to go down the barrister route and find a public access barrister. But I reiterate that this lecture is not legal advice, and it's for educational purposes only. So with that out of the way, let's go on to the learning objectives. What do we plan to cover in this lecture? So we're going to start by defining what is legally meant by terrorism. So we might all have our own ideas of what terrorism is, but how does the law define terrorism? What's the legal definition? We will then look at the legislation around proscribing certain organisations and look at the process of proscribing those organisations. We will then cover the basic law around protests, when you're protesting, what is allowed and what is not allowed, and what you can be arrested for and even sent to prison for, and what is well within your rights when you are protesting. We will also describe the relevancy of human rights legislation, because that is an area which really does fit in with this lecture, focusing on issues of proscribed organisations, terrorism, freedom of speech, etc, etc. So we'll be looking at the human rights legislation in England and Wales, and then some of the more practical objectives is we plan to apply the law to both factual and fictional scenarios, which we will do throughout this lecture, and then we will also critically analyse the law in this area, and I will include a bit about what critical analysis is later on in this lecture. But really it's just thinking about the law. Is the law just? Is the law appropriate? Is the law fair? Is the law right? Or is the law wrong? And is it in need of reform? But before we go any further into this content, we're going to look at a problem scenario first, which will help illustrate the points throughout this lecture. So, this problem scenario is about the Freedom Front and the Green Uprising. And the problem goes like this. In response to growing public frustration over government inaction on the climate crisis, two movements have gained prominence across the UK. Though their aims are similar, demanding radical environmental reform, their methods, reputations, and the state's response to them differ significantly. The Freedom Front began as an underground movement aiming to forcibly disrupt what it called ecocide by government neglect. Its activities have included targeted attacks on oil company vehicles, chaining activists to the entrances of corporate offices, and damaging machinery used in new fossil fuel projects. Their online materials frequently contain messages encouraging people to defy the law, disrupt the system, and dismantle the infrastructure of destruction. In interviews and social media posts, spokespeople for the group have openly stated that their tactics are intended to pressure the government by causing fear and economic pain, which they argue is necessary to prevent environmental collapse. After a string of disruptive incidents involving the group, the Home Secretary declared the Freedom Front a proscribed organisation under Section 3 of the Terrorism Act 2000, asserting that its activities met the criteria under Section 1, particularly in aiming to influence government policy through intimidation and serious disruption. Shortly after the proscription, Samir, who had attended several meetings of the Freedom Front prior to its proscription, continued to participate in internal group discussions and posted a series of videos online identifying himself as a proud member. In interviews, he insisted he was engaged in educational outreach and that none of his activities post-proscription had involved violence. Meanwhile, Layla, a well-known environmental advocate and public speaker, gave a televised speech at a protest in which she said she fully supports the mission and courage of the Freedom Front. She made it clear that while she did not condone the destruction of property, she admired the group's willingness to act where others would not. Separately, Milo, a YouTuber with a large following, filmed a satirical video in which he wore a Freedom Front branded black jacket and face covering, mimicking some of their online rhetoric. He posted the video on social media with the caption, "If standing up to ecocide makes me a terrorist, then so be it." Although the video was comedic in tone, some viewers commented that it could be seen as glorifying the organisation. By contrast, another movement called the Green Uprising has pursued similar climate goals through civil disobedience. Its members have conducted peaceful occupations of petrol stations and banks, handed out anti-fossil fuel leaflets, and staged flash mob performances criticising the Freedom Front's proscription. The group has also launched a campaign arguing that the Freedom Front's ban amounts to a direct attack on freedom of conscience and the right to protest. Some members of the Green Uprising have taken to wearing green jumpsuits with the movement's logo, prompting public complaints that they are attempting to intimidate by appearance. The Green Uprising has not been proscribed. While the protests have at times disrupted traffic and caused public complaints, the police have not taken action beyond occasional arrests for trespass and obstruction. Both groups have attracted attention from civil liberties organisations, with debate raging about the limits of political expression and the government's use of proscription powers in the context of environmental activism. And for this problem question, we are asked to advise Samir, Layla and Milo on their potential criminal liability under the Terrorism Act 2000, focusing on the legal implications of continued association with and support for a proscribed organisation. And then we are also asked to advise the Home Secretary on whether the proscription of the Freedom Front is legally sustainable under the Terrorism Act 2000, and whether any legal distinctions between the Freedom Front and Green Uprising are relevant to future proscription decisions. So, now let's look at a real-world example of this area, and that is going to be Palestine Action. Palestine Action is a UK-based direct action group founded in July 2020, and it's known for targeting companies tied to arms trade with Israel, notably Elbit Systems, through property damage, factory intrusions and other disruptive tactics. Their aim has been to pressure the UK government and private companies to cut ties with Israeli arms manufacturers, and it opposes what it describes as UK complicity in the oppression of Palestinians. On July 2025, Palestine Action was officially proscribed under the Terrorism Act 2000, and this status criminalises membership, support, promotion or displaying symbols of the group, carrying penalties up to 14 years in prison and the lesser offences up to 6 months. Now that we've seen both a fictional scenario and a real world scenario, this is the key legislation which we will be looking at today. So the Terrorism Act 2000 is the main legislation when it comes to the terrorism law in England and Wales, and under the Terrorism Act it gives the Home Secretary the permission to enact further legislation under statutory instruments to proscribe future organisations. And so it's under one of these statutory instruments which Palestine Action was proscribed, and it was proscribed with 2 other organisations which were unrelated to the Israel-Palestine conflict. We will also look briefly at the Human Rights Act 1998 and what that means for citizens of England and Wales, as well as the European Convention on Human Rights, which is international law. And then we will finally look at equality, the Equality Act 2010, to see the characteristics which are protected and which you cannot be discriminated against, especially by public authorities. And so now we will get into this legislation and we will look at what is terrorism. But before I give you the legal definition, I would encourage you to type in the comments section below, in your own words, what do you think terrorism is? In your opinion, what is terrorism? That's because the law is very much meant to be focused on what we as a society believe is right and wrong, and it's meant to criminalise that which we as society think is wrong. And so it'd be interesting to see what your definitions of terrorism is in your opinion. But I've given you a few moments to comment your definition, so if you haven't done so already, I would recommend you pause the video here. But we will now move on to the law proper. So what is terrorism? Under Section 1 of the Terrorism Act 2000, the term terrorism means the use or threat of action, where the action falls within subsection 2, which is below. The use or threat is designed to influence the government or an international governmental organisation, or to intimidate the public or a section of the public, and the use or threat is made for the purpose of advancing a political, religious, racial or ideological cause. Under subsection 2, action falls within this subsection if it involves serious violence against a person, involves serious damage to property, endangers a person's life other than that of the person committing the action, creates a serious risk to the health and safety of the public or section of the public, or is designed seriously to interfere with or seriously to disrupt an electronic system. The use or threat of action falling within subsection 2, which involves the use of firearms or explosives, is terrorism, whether or not subsection 1b is satisfied. So the main parts of this part of the definition is that there needs to be some form of violence or damage which is serious. It should endanger someone's life, but not the person who's carrying out these actions. And then it should also create a serious risk to the health and safety of the public at large, or a smaller section of that public. And if it disrupts an electronic system, so arguably if a scammer was hacking into an online system as part of a terrorism organisation or terrorist activities, then that would technically come under this definition. In relation to Palestine, conveying a message personally in relation to a topic such as the war would not come under this definition of terrorism, in my opinion, unless it involves some form of indictable criminal offence. Indictable meaning really serious, and that could be violence, damage to property, or risks to the health and safety of the public. But sharing an opinion online or directly helping individuals in need cannot ordinarily be defined as terrorism according to this legislation. And indeed, if you are helping someone in need, whether that's Palestinians or whoever else, that's not really endangering other people's lives, I would argue. And so it's questionable whether it could be argued it would come into this section. But section 1 continues under subsection 4, and it says that in this section, action includes action outside the United Kingdom. So if you did go to a different country, wherever that is in the world, and you carry out some form of action, which under this definition of terrorism would be a terrorist activity, then you can still be liable in the United Kingdom. A reference to any person or to property is a reference to any person or to property wherever situated. So again, that personal property can be anywhere. A reference to the public includes a reference to the public of a country other than the United Kingdom. And the government means the government of the United Kingdom, or of a part of the United Kingdom, or of a country other than the United Kingdom. And in this act, a reference to action taken for the purposes of terrorism includes a reference to action taken for the benefit of a proscribed organisation. And so essentially what this means is that any action which causes violence, risk of health and safety, or interference with systems in relation to political, religious, racial or ideological causes can still lead to prosecution in England and Wales, even if these actions take place in another country. So this legislation here is part of many examples where it doesn't have to be committed in the country in question, i.e. England and Wales, for it to be punished or prosecuted in this country. It's similar with murder, for instance, or other homicide. You can still be tried in England and Wales, even if you commit murder in a different country altogether. And so that's something really key to remember. You are not protected if you carry out actions in relation to this legislation in other countries. But let's explore this definition in a bit more detail by applying it to a problem example. So, in the first part, the Freedom Front began as an underground movement aiming to forcibly disrupt what it called ecocide by government neglect. Its activities have included targeted attacks on oil company vehicles, training activists the entrances of corporate offices, and damaging machinery used in new fossil fuel projects. Their online materials frequently contain messages encouraging people to defy the law, disrupt the system, and dismantle the infrastructure of destruction. In interviews and social media posts, spokespeople for the group have openly stated that their tactics are intended to pressure the government by causing fear and economic pain, which they argue is necessary to prevent environmental collapse. And so, let's see if this can meet the definition of terrorism under Section 1 of the Terrorism Act 2000. So, it needs to involve a use of threat, which is designed to influence the government or to intimidate the public or a section of the public. So, because it's or and not and, it can either influence the government or instead intimidate the public, or instead intimidate a section of the public. And so, if we look at here, there is evidence that they are trying to influence the government. So, its actions have included targeting attacks on oil companies, damaging machinery, defy the law, disrupt the system, and in interviews, here it is, they are intended to pressure the government. Excuse my dodgy highlighting, but this is the key term here which we'd want to look at and explore more in a fuller answer of the problem question. So the first part of this legislation is satisfied, I would argue, because that could be argued to be influencing the government. Now it needs to involve serious violence against the person. I don't think we've got evidence of that at a glance of this problem, but involves serious damage to property, which I would argue we do. For instance, targeted attacks on oil company vehicles, damaging machinery as well. So there's a few areas there. Endangers a person's life other than that of the person committing the action. I don't think there's any endangerment of life in here, but obviously alternative interpretations are allowed and a big part of law. Creates a serious risk to the health or safety of the public or section of the public. Arguably that could be argued here. Define the law, for instance, disrupting the system, dismantle the infrastructure. That could all be evidence of risk in the health and safety. Seriously interfere with or seriously disrupt an electronic system. Disrupt the system and dismantle the infrastructure, for instance. And the use of threat, but they are forcibly disrupting, so I'd say that would come under threat. And I think there's also other examples there as well. Action is in reference to any personal property and wherever situated. Well, all of this is happening in the UK, we're going to assume. And so, Section 3 would allow proscription where the Secretary of State believes an organisation is concerned in terrorism. And so, when we look at the methods of the Freedom Front, they are aiming to influence the government, and they are sabotaging, they are intimidating, and so it looks like it is highly likely that the Freedom Front would satisfy the Section 1 definition of terrorism. By contrast, however, another movement called the Green Uprising has pursued similar climate goals through civil disobedience. Its members have conducted peaceful occupations of petrol stations and banks, handed out anti-fossil fuel leaflets, and staged flash mob performances criticising the Freedom Front's proscription. The group has also launched a campaign arguing that the Freedom Front's ban amounts to a direct attack on freedom of conscience and the right to protest. Some members of the Green Uprising have taken to wearing green jumpsuits with the movement's logo, prompting public complaints that they are attempting to intimidate by appearance. So, by contrast, Green Uprising is committed to non-violent civil disobedience, and so this doesn't automatically satisfy the Section 1 threshold for terrorism, and instead I would suggest that we'd want to look at the law of protest instead. But we can probably conclude that the prescription of the Freedom Front is likely unlawful, whereas this, the Green Uprising, is likely not going to be unlawful under Section 1 because of their differences in tactics. And we're now going to look at this using another real-world example. So, Palestine Action have been known to sabotage property, for instance red paint resembling blood thrown on buildings, scaling factory roofs and disabling machinery, graffiti and damage to Albit Systems premises, and damage of around £7 million to military aircraft. Whereas the Provisional IRA, Irish Republican Army, were engaged in bombings, including the Birmingham pub bombings in 1974, assassinations, including the attempted assassination of Lord Mountbatten in 1979, and attacks on military police and civilians both in Northern Ireland and on the British mainland. And so there's a bit of a distinction to be drawn here. These are two cases where these organisations have been proscribed, both at different times. So the Provisional IRA appears to be much more serious and seems to present a much more serious threat to the public, i.e. bombings and assassinations and attacks. Whereas Palestine Action, could that be argued just to be protesting going a step too far? Especially with the first three? Yes, that likely satisfies the definition of terrorism, for instance damaging property and trying to influence the government, which is the aim of Palestine Action. And I think the damage of the aircraft is probably one of the biggest reasons why the government thought that Palestine Action needed to be proscribed. But it's worth mentioning, has the Home Secretary who would have proscribed Palestine Action gone a step too far? Did Palestine Action really present a danger? And is it just to proscribe them as an organisation? Is the law in this area right? Was the law in this area right to prescribe Palestine Action? And this is a start of where we might want to look at the critical analysis part of this lecture. What, in your opinion, was the right approach? Is this the right approach? I won't say what I think, but I'll leave it open to you, and do let me know in the comments section as well. But now moving on, let's have a look at the law around proscription, which is again under the Terrorism Act 2000. So Section 3 covers proscription, and it says for the purposes of this act, an organisation is proscribed if it is listed in Schedule 2 or it operates under the same name as an organisation listed in that schedule. So all the proscribed organisations are included in Schedule 2 of this legislation, even if they were proscribed after this legislation was published. And if it's another group which goes by the same name as an organisation listed in that schedule, then it will also be proscribed. And subsection 1b shall not apply in relation to an organisation listed in Schedule 2 if its entry is the subject of a note in that section. And the Secretary of State may by order add an organisation to Schedule 2, remove an organisation from that schedule, and amend that schedule in some other way. So this section 3 is what gives the Secretary of State a power to add any organisation they like to this Schedule 2 if it meets the definitions and the requirements of the process under this statute. It can also remove an organisation from the schedule at any times and amend the schedule in any other way it sees fit as well. So that gives the Secretary of State all of that power, which is really important to consider. And as we have different Secretary of States with different governments, will what is prescribed and not prescribed vary. Is it really based on the law, or is it really based on their opinion, whether political or personal? That's another area to consider when looking at critical analysis in this area. But subsection 4, the Secretary of State may exercise his power under subsection 3a in respect of an organisation only if he believes that it is concerned in terrorism. So here we go again. For the Secretary of State to exercise his power to add an organisation, he must believe that it is concerned in terrorism. So just to clarify, that doesn't matter whether the Home Secretary is male or female or something completely different, but it's only if he is concerned, if he believes the organisation is concerned in terrorism. So it could be argued that this is a somewhat subjective analysis of the organisations, and subsection 5 goes on to say, for the purpose of subsection 4, an organisation is concerned in terrorism if it commits or participates in acts of terrorism, prepares for terrorism, promotes or encourages terrorism, or is otherwise concerned in terrorism. And I'll say in subsection 5b, prepares for terrorism, is also worthy to think about, because where do we draw the line between preparing for protest and preparing for terrorism? I would argue that it could be argued it's quite subjective, and it also really depends on how the government are treating the issue. For instance, the illegal immigrants, for many they might see that the government are not doing much or anything to fix the problem or the perceived problem for those protesting against it, and so those protests get more violent because they don't seem to be listened to. But at what stage does that go from protesting with some violence to terrorism? And is it just a sign that maybe the government needs to listen to the people more, because we are in a democratic society where the government are meant to be representing the public at large? And so it's all these bigger issues which we should also consider when analysing this law from an academic perspective. In relation to Palestine Action and the interference with military resources and the encouragement of criminal behaviour, they, I would say, are amongst the reasons why Palestine Action has been considered a terrorist organisation, and it has a negative risk against the security of the United Kingdom. So by interfering with arms supplies in the UK and damaging military aircraft, I would believe that the Secretary of State saw that as threatening the national security of the UK, making us less war ready or conflict ready, and so the Secretary of State likely thought that if they did not take action, then if we did get into conflict, we might not be as ready. But moving on, under section 5a, the cases in which an organisation promotes or encourages terrorism for the purposes of subsection 5c include any case in which the activities of the organisation include the unlawful glorification of the commission or preparation, whether in the past, in the future, or generally, of acts of terrorism, or are carried out in a manner that ensures that the organisation is associated with statements containing any such glorification. So I'd say that means I'm looking at terrorism in a positive way, whether that's a commission, the carrying out of the terrorist actions, or preparing for terrorist actions. 5b goes on to say that the glorification of any conduct is unlawful for the purpose of subsection 5a if there are persons who may become aware of it, who could reasonably be expected to infer that what is being glorified is being glorified as conduct that should be emulated in existing circumstances, or conduct that is illustrative of a type of conduct that should be so emulated. And 5c in this section, glorification includes any form of praise or celebration, and cognate expressions are to be construed accordingly, and statement includes a communication without words consisting of sounds or images or both. And so thinking about Palestine Action again, if you are praising or celebrating the actions of that group, for instance their damage of the military aircraft, that could be seen as supporting the group, and so that could technically be an offence under this section of the Terrorism Act 2000. This legislation then continues to go on, as we will see. And before we do go on, it's worth mentioning that a statement includes communication consisting of sounds or images or both. And so it doesn't have to be in person, it could be a social media post or even a video. Then we go on. Where the Secretary of State believes that an organisation listed in Schedule 2 is operating wholly or partly under a name that is not specified in that section, whether as well as or instead of under the specified name, or that an organisation that is operating under a name that is not so specified is otherwise for all practical purposes the same as an organisation so listed, he may by order provide that the name that is not specified in that section is to be treated as another name for the listed organisation. And so this is a way to ensure that terrorist groups cannot continue to be in action under different names. But this can also be problematic, particularly with regards to current protests which are happening in the current climate. So using the Palestine protest again, if there's a group under a different name, but that arguably they are carrying out the same actions as Palestine Action, the Secretary of State may also prescribe that group. And this could be an area of concern, because if the Secretary of State does ban other groups, is that them limiting freedom of speech, even if they're not carrying out the direct actions, but mainly carrying out the message of Palestine Action? And could this be used disproportionately just to silence the British public, which would be a cause of concern in what is meant to be a democratic society? But going on, under subsection 7, where an order under subsection 6 provides for a name to be treated as another name for an organisation, this act shall have effect in relation to acts occurring while the order is in force and the organisation continues to be listed in Schedule 2. And as if the organisation were listed in the schedule under the other name, as well as under the name specified in that schedule. And the Secretary of State may at any time by order revoke an order under subsection 6 or otherwise provide for a name specified in such an order to cease to be treated as a name for a particular organisation. So if an organisation was prescribed under subsection 6, then the Secretary of State does have the power to revoke that order, so the name would no longer be treated as part of the prescribed organisation. And finally, in subsection 9, nothing in subsection 6 to 8 prevents any liability from being established in any proceedings by proof that an organisation is the same as an organisation listed in Schedule 2, even though it is always operating under a name specified neither in Schedule 2 nor in an order under subsection 6. So even if an organisation is not in Schedule 2 or has not been specified as being treated as a prescribed organisation under schedules under subsection 6, there's nothing which prevents liability from being established if an organisation is the same as one in Schedule 2 and carry out any of the actions. So let's have a look at why Palestine Action may have been prescribed. A large part of it would be extensive damage to buildings and vehicles, particularly targeting arms manufacturers and infrastructure, but particularly the RAF Bryce Norton incident in June 2024, where activists caused £7 million worth of damage to 2 RAF Voyager aircraft. And as previously mentioned, this from the government's perspective would likely threaten the public security and the military resources of the UK, hence why they saw it as necessary to proscribe this organisation. There have also been repeated attacks on UK defence supply chains and companies linked to Israel's military. And again, both of these points disrupt the military readiness and operations in the UK. And there have been operations active in all 45 UK policing areas. And this shows scale and strategic coordination. And so that takes it from what may be seen as ordinary protests organised on a local level to something which is a bigger problem, because it's seen as this organisation has had a bigger impact. And the reasons go on for the use of violent and aggressive tactics. So this can be intimidatory and aggressive methods, which the government considers the group's methods to cross the line from protest to coercion and serious intimidation. They've also been training and encouraging others to take unlawful action through promotion of direct action and sabotage, including publication of a how-to guide and detailing sabotage techniques. Encouraging others to commit offences. The government stated that the group incited others to commit criminal acts and potentially qualifying as the use or threat of action designed to influence the government or intimidate the public. So that's part of the reason why they might be proscribed. There's evidence of coordinated planning and strategy beyond spontaneous protest. So that really shows an organised hierarchy and strategy beyond spontaneous protest, meaning there's likely been internal communications, meaning there's likely been centralised decision making and target planning. But there's also been threat to public order and safety. This is what the Home Secretary has claimed, and particularly under the serious violence against people or property. And officials believe that maybe this is presenting a risk to the life and public safety, even if it has been indirectly. And finally, the justification or glorification of terrorism. So some government officials have indeed suggested that maybe Palestine Action have justified or celebrated other acts of violence against property or military targets, which they would argue further strengthens the basis for proscription. And so these are all the areas which the government would have taken into account when looking at proscribing Palestine Action and the role they have in the Israel-Palestine conflict and the impact they've had on the public security of the United Kingdom. So let's now move on to our problem example again to look at where this may come into play in our scenario and continue to apply this legislation. So the Secretary of State may add any organisation to the Schedule 2 at any time, and so they may exercise power if the organisation commits or participates in acts of terrorism, prepares for terrorism, promotes or encourages terrorism, or is otherwise concerned in terrorism. So we have already decided that it's highly likely that the Freedom Front is involved in terrorism, and we will look at that again. For instance, there's been targeted attacks on oil company vehicles, chaining activists to the entrances to corporate offices, damaging machinery, so there's lots of damage to property evident here. They've got online materials encouraging people to defy the laws and disrupt the system and dismantle the infrastructure of destruction. So that could be argued to be similar to the Palestine Action reasons. And apparently there's been pressure to the government by causing fear and economic pain, which they argue is necessary. It goes on to say that after a string of disruptive incidents involving the group, the Home Secretary declared the Freedom Front a proscribed organisation, asserting that its activities met the criteria, particularly in aiming to influence the government policy through intimidation and serious disruption. And so they believe there is terrorism, and so the Freedom Front seems to be influencing the government through methods such as sabotage and intimidation, and rhetoric align with Section 1. And so the threshold for proscription is also relatively low, so belief rather than proof is necessary for this section to be satisfied, and for the Secretary of State to prescribe a organisation. And that's key, because again that's making it more subjective, because only a belief is needed and not proof. And so if you were to respond and answer this question, we'd like to see more of a discussion in whether it satisfies the necessary legislatory requirements which are concerned here, and whether if the Green Uprising, whether they were supporting the issues raised by Freedom Front and maybe started doing some of these things like damaging machinery or targeted attacks, could they potentially be proscribed as well under some of these subsections listed in this section of the Act. But anyway, let's move on now to Section 11 of the Terrorism Act, which is concerned with membership. So it provides that a person commits an offence if he belongs or professes to belong to a proscribed organisation. It is a defence for a person charged with an offence under subsection 1 to prove that the organisation was not proscribed on the last or only occasion on which he became a member or began to profess to a member, and that he has not taken part in the activities of the organisation at any time while it was prescribed. So here, the law is essentially saying that if someone is a member of the organisation which has been prescribed, that is okay. They can use the defence and not be charged, or try not to be charged, if they can prove that they were only a member before the organisation was prescribed. But if they continue to be a member and participate after the organisation has been prescribed, that is unlawful and can be charged with an offence under subsection 1. And that doesn't just involve membership, but also any activities of the organisation whilst it is prescribed. And so essentially, an individual can only be convicted if they belong or suggest that they belong to a prescribed organisation, whereas general opinions or activism in regard to a general topic will not satisfy this offence unless done under the identity of the organisation. So looking at our problem scenario, general activism or opinions about climate change, climate crisis, could not be unlawful unless it is going under the name or the individual is portraying to be a member of the Freedom Front. And this point clarifies that if you have not taken part in any of the activities of the organisation whilst they have been a prescribed organisation, this would indeed be a defence if you were convicted under this section. But this section continues by saying that a person guilty of an offence under this section shall be liable on a conviction on indictment, meaning this is a particularly serious offence which would be tried in the Crown Court, to imprisonment for a term not exceeding 14 years, to a fine, or to both, and on the summary conviction, meaning in the Magistrates' Court, to imprisonment for a term not exceeding 6 months, to a fine not exceeding the statutory maximum, or to both. And in subsection 2, prescribed means prescribed for the purposes of any of the following, which I won't go through right now. But essentially, this is showing the statutory guidelines on the different punishments which you could get. So that's either imprisonment, going to prison, or a fine, or you could be given both. But it's worth mentioning that the actual punishments are now decided by the Sentencing Council, and so this punishment situated in the actual section of this statute should be seen as guidance only, and for more accurate information, the courts would go to the Sentencing Council to see what has been held there. But let's have a look at this in relation to our problem example. Shortly after the proscription, Samir, who had attended several meetings of the Freedom Front prior to its proscription, continued to participate in internal group discussions and posted a series of videos online identifying himself as a proud member. In interviews, he insisted he was engaged in educational outreach, that none of his activities post-proscription had involved violence. So this is a really interesting section to actually look at. So, a person commits an offence if he belongs or professes to belong to a proscribed organisation. And so looking at this, he continues to participate in internal group discussions. So that would be evidence that he is continuing to participate in the group even after it's been proscribed. And he's identified himself as a proud member following the proscription. And so this would prima facie, meaning on the face of it, be unlawful, and Samir would likely be charged with an offence under Section 11 of the Terrorism Act. And it's unlikely that he will be able to rely on any defence. But having said that, if he had attended these several meetings and charged with an offence before the Freedom Front was proscribed, that would be a defence. But because there's evidence to suggest he's continued to act and participate in internal group discussions and being a proud member, it's likely that he would be liable under this section. And when it comes to educational outreach, I would suggest that really doesn't matter. If it was educational outreach on a topic in general, okay, that would likely be allowed, but it's educational outreach under the name of Freedom Front, and so that's still associated with Freedom Front, which is a proscribed organisation, and so I would suggest that it's unlawful. And it doesn't even matter whether the actions pro-proscription have involved violence or not. It's association with this group which is unlawful, not necessarily violent actions. And so this would be the areas which you would particularly want to have a look at if you were answering this question. Then continuing on, section 12 is support, and this provides that a person commits an offence if he invites support for a proscribed organisation, and the support is not restricted to the provision of money or other property within the meaning of section 15. So this means it doesn't have to just be money or property, it can be any other support as well. A person commits an offence and the person expresses an opinion or belief that is supportive of a proscribed organisation, and in doing so is reckless as to whether a person to whom the expression is directed will be encouraged to support a proscribed organisation. A person commits an offence if he arranges, manages or assists in arranging or managing a meeting which he knows is to support a proscribed organisation, to further the activities of a proscribed organisation, or to be addressed by a person who belongs or professes to belong to a proscribed organisation. And a person commits an offence if he addresses a meeting and the purpose of his address is to encourage support for a proscribed organisation or to further its actions. And so, essentially, any support or comments in favour of the organisation I would suggest could support them would be unlawful. Therefore, if one was to engage in activism regarding a certain topic, they should not mention the proscribed organisation in a way which would support their activities, and should ideally sever any ties they have with the organisation. So this would include, if they followed the proscribed organisation on social media, they should unfollow at the soonest convenience and essentially not show their support or show any link to the proscribed organisation in any way. And one should not at any point mention or say anything about or in relation to the proscribed organisation if they wanted to be protected. And so, taking our problem example, environmental concerns yes, you can talk about that, but don't talk about Freedom Front or what they've done or their key messages, unless they were strictly well away from the organisation. I would not be seen as supporting. Going on, where a person is charged with an offence under subsection 2c in respect of a private meeting, it is a defence for him to prove that he had no reasonable cause to believe that the address mentioned in subsection 2c would support a proscribed organisation or further its activities. In subsections 2 to 4, meeting means a meeting of 3 or more persons, whether or not the public are admitted, and a meeting is private if the public are not admitted. A person guilty of an offence under this section shall be liable, on conviction on indictment, to imprisonment for a term not exceeding 14 years, to a fine, or to both, or on summary conviction, to imprisonment for a term not exceeding 6 months, to a fine not exceeding the statutory maximum, or both. So, someone can be charged with an offence if they have organised or are involved in a private meeting, but it's a defence for him to prove that he had no reasonable cause to believe that the address mentioned in subsection 2c would support a proscribed organisation. But under this subsection, a meeting is a meeting if it's 3 or more persons, regardless of whether the public are admitted. So it could be 3 or 4 of your closest friends, or 3 or 4 members of the public. But a meeting is private if the public are not admitted. So there are the key ideas there. So one should not talk about a proscribed organisation in a way which would support the organisation in a group of 3 or more people, because in reality supporting a proscribed organisation, regardless of the number of people, would raise red flags, and talking about the impact of proscribing an organisation would be, for oneself, I would suggest, would not be supporting the organisation, as I would suggest not lead to criminal liability. But this is probably an ideal point in this lecture to remind you that none of the contents of this lecture does constitute legal advice, and this lecture is for educational purposes only, and if you do require legal advice, you must go to a licensed legal professional, most likely a solicitor or a barrister who specialises in this area. Let's have a look and apply this legislation to our problem example again. So meanwhile, Layla, a well-known environmental advocate and public speaker, gave a televised speech as protest, in which she said she fully supports the mission and courage of the Freedom Front. She made it clear that while she did not condone the destruction of property, she admired the group's willingness to act where others would not. And so this is, I would suggest, 2 good points which you could make in a problem question. So she's a well-known environmental advocate and public speaker, and so that on its own is not unlawful, and you might want to have a discussion of how that's allowed, and she would be allowed to do that. But here we have the words that she fully supports the mission and courage of the Freedom Front. So this is very clearly her support in the organisation, even if she does not condone the destruction of property. She's still admiring the group's willingness to act, and so it doesn't matter whether she's agreeing with their methods or not. I would argue that she is supporting the organisation, the people who belong to it, and the aims of their organisation. And so I'd say there is indeed a risk of prosecution under section 12, because yes, there's support of the proscribed organisation, but some might argue that human rights, and particularly Article 10 of the ECHR, may mitigate this. This is something we will look at a bit later on, but these are some of the key points you would want to look at if you were to answer this question. Moving on is section 13, which is regarding uniform and the publication of images. So, a person in a public place commits an offence if he wears an item of clothing wears, carries or displays an article in such way or in such circumstances as to arouse reasonable suspicion that he is a member or supporter of a proscribed organisation. So this would be anything which makes you look like you belong to a proscribed organisation or you support. And arguably this could also touch on section 12 if you are supporting. And a person commits an offence if that person publishes an image of an item of clothing or any other article, and in such way or in such circumstances as to arouse reasonable suspicion that the person is a member or supporter of a proscribed organisation. So if we said you were protesting and you wore a t-shirt for, let's say, the Freedom Front, even if you were not a member, that would look like you were a member, and so it's highly likely that that could be an offence under this section. But the reference to an image in a reference to a still or moving image is produced by any means, so arguably that could even be an AI generated image or video, so that's still worthy of thinking about. And it's also worth mentioning that one should not do anything which may make it seem that they are part of the proscribed organisation. But this isn't limited to not wearing any clothes or symbols, the proscribed organisation, but also contains any identifying marks which would point to the proscribed organisation. And I reiterate, one cannot publish anything online which would suggest they were a member of a proscribed organisation or support it. But it is not illegal to publish material online about the topic or cause on a wider scale. It just may not have any reference to a prescribed organisation. It's only when you start having reference to the prescribed organisation, whether implicitly or explicitly, when it becomes problematic. Moving on, a person guilty of an offence under this section shall be liable on summary conviction to imprisonment for a term not exceeding 6 months, a fine not exceeding level 5 on the standard scale or both. And the constable may seize an item of clothing or any other article if the constable reasonably suspects that it is evidence in relation to an offence under subsection 1. So this means if you have an item of clothing or any other article which might be seen as uniform or supporting a prescribed organisation, a police officer can confiscate it if they believe it's evidence of an offence committed. But it must be satisfied that it is necessary to seize it in order to prevent the evidence being concealed, lost, altered or destroyed. So if the police think that if they don't take the evidence, you will destroy it, alter it or whatever else to make it unlawful, then they will have to take it away. But in connection with exercising this power, a constable may require a person to remove the item of clothing or other article if the person is wearing it, but this may not be exercised so as to seize or require a person to remove an item of clothing being worn either next to the skin or immediately over a garment being worn as underwear. So if it was trousers, for instance, or a shirt, that would not be allowed to be removed. But if it was a hoodie, for instance, I would argue that would be allowed to be removed. So, looking at this problem example to put it all together, Milo, a YouTuber with a large following, filmed a satirical video in which he wore a Freedom Front branded black jacket. So he wore a Freedom Front branded black jacket and face covering, and he filmed a video and he was mimicking some of their online rhetoric. He posted the video on social media with the caption, "If standing up to each side makes me a terrorist, then so be it." I'll highlight that as well. Although the video was comedic in tone, some reviewers commented that it could be seen as glorifying the organisation. So, he is clearly wearing branded clothing and face mask, and so, face covering, so that could be seen as a uniform for the proscribed organisation. And the fact that he's not just wearing it in private, but that he is actually wearing it on a video which he's published into social media, makes it look like he's part of the organisation or supports it. And his comment that if standing up to each side makes him a terrorist, then so be it. This could really strongly indicate that he is willing to be a terrorist for this cause. As silly as that may sound, that might be seen as terrorism, and so he could be guilty under the Section 13 of the Terrorism Act 2000 in terms of publication of uniform and images and wearing such. So that finishes and concludes the main part of this lecture, focused on the terrorist law. But now we will move on. We now move on to the law of protests, and we look at what is allowed and what is not allowed when it comes to protesting. And so there's two main pieces of legislation here. The first, the Public Order Act 1986, which is the main bit of legislation and is the legislation which really gave effect to much of the law. But then we also have the Police Crime Sentencing and Courts Act 2022. But that section, that act, really just amends some of the sections in the Public Order Act, meaning that it essentially updates some of the some of the law in the Public Order Act, or the POA. We're just going to look at the POA today, but I will make references to where statutes are pending amendment. So firstly, we need to look at Section 16 of the POA, which concerns interpretation. So under this legislation, there are two different things: public assembly and public procession, and they're both in regards to protest. So a public assembly means an assembly of two or more persons in a public place which is wholly or partly open to the air. And public place means any highway, or in Scotland any road within the meaning of the Roads Scotland Act 1984, and any place to which at the material time the public or any section of the public has access on payment or otherwise, as of right or by virtue of express or implied permission. And public procession means a procession in a public place, and it means the same definition of public place. So I think the key part of public place is that the public have access to it, and that's regardless of whether the public have to pay to get access or whether they can access for free. So let's have a look at the law proper when it comes to protests, public processions, etc. So Section 11 of the POA concerns advance notice of public processions, and so this is the first legal requirement to have a legal protest, as I will say. So it provides that written notice shall be given in accordance with this section of any proposal to hold a public procession intended to demonstrate support for or opposition to the views or actions of any person or body of persons, to publicise a cause or campaign, or to mark or commemorate an event, unless it is not reasonably practicable to give any advance notice of the procession. So most of the time, in all circumstances, you must give written notice of any proposal to hold such a public procession for it to be legal. But there will be times when advance notice is not practical and will be okay without. But as I keep mentioning, this isn't legal advice. If you want legal advice of whether your public procession requires notice or not, go and speak to a qualified lawyer, either solicitor or barrister. But looking at this, I'd suggest that a protest or public procession concerning the war between Israel and Palestine, to publicise a cause or campaign in relation to that, would be legal if you follow these steps. But Section 1 does not apply where the procession is one commonly or customarily held in the police area, or areas in which it is proposed to be held, or is a funeral procession organised by a funeral director acting in the normal course of his business. So essentially, if there's a regular procession of some form which often takes place, written notice is not required, largely because it gets to a point where it's expected, and the police in particular expect it to happen. But also funeral processions. We all know what a funeral is, and they are very common. And so if we see a black hearse, we know that there's a funeral going on somewhere, particularly if there's the coffin in the back. And so a funeral director who is carrying out his normal duties does not need permission for a public procession, which may often be a procession of vehicles travelling to the place where the funeral is to take place. But the notice must specify the date when it is intended to hold the procession, the time when it is intended to start, its proposed route, and the name and address of the person or of one of the persons proposing to organise it. And so they are the key details which must be included in your notice. I repeat, the time when it is intended to start, the route you propose to take, and the name and address of one of the people proposing to organise it. And this notice must then be delivered to a police station in the police area in which it is proposed the processions will start. So if you are saying you want to lead a public procession in London, for instance, that notice will have to go to the London police, not the police in Manchester, for instance. And where it is proposed the procession will start in Scotland and cross into England, in the first area in England on the proposed route. So this means that if there's a protest in Scotland which plans to travel into England, they will have to let the Scottish police know, and they will also have to let the police know based on the area they will first be entering in the UK. This section goes on to say that if delivered not less than 6 clear days before the date when the procession is intended to be held, the notice may be delivered by post by the recorded delivery service, but Section 7 of the Interpretation Act 1978, under which a document sent by post is deemed to have been served when posted and to have been delivered in the ordinary course of post, does not apply. And this touches a bit on the law of contract and the postal rule. That idea being that if you are entering a contract by post, unless it says otherwise, when you post that acceptance of the contract back, that's when the contract starts. But when it comes to notice for public processions, it's not when the notice is posted, but when it has been received, according to subsection 5. Subsection 6 goes on to say that if not delivered in accordance with subsection 5, the notice must be delivered by hand not less than 6 clear days before the date when the procession is intended to be held, or if that is not reasonably practicable, as soon as delivery is reasonably practicable. So ideally, if you're not going to deliver it by post, you need to deliver it by hand, ideally 6 clear days before or as soon as possible thereafter. But where a public procession is held, each of the persons organising it is guilty of an offence if the requirements of this section as to notice have not been satisfied. So in order to be legally protected for protests, and for it to be a legal protest, this notice is very much essential. But also, if the date when it is held, the time when it starts, or its route differs from the date, time, or route specified in their notice, that can also be an offence. But if you need to change any of it for any reason whatsoever, I would suggest you need to let the police know as soon as possible. We go on. Section 8 says that it is a defence for the accused to prove that he did not know of, and neither suspected nor had reason to suspect the failure to satisfy the requirements, as the case may be, the difference of date, time, or route. So if the time, date, or route has changed, and the people organising the protest had no reason to think that they would need to make those changes, or the failure to satisfy the requirements, or had no reason to suspect those changes, then that would technically be a defence. And Section 9 goes on to say that to the extent that an alleged offence turns on a difference of date, time or route, it is a defence for the accused to prove that the difference arose from circumstances beyond his control or from something done with agreement of a police officer or by his direction. And so this goes back to what I just previously said. If you need to make any changes when you're protesting, you really need to make a police officer aware and ideally get their agreement, because then that will be a defence which will stop you from being charged with a criminal offence under this legislation. But a person guilty of an offence under subsection 7 is liable on summary conviction to a fine not exceeding level 3 on the standard scale. But that will also depend on culpability and many other factors, and as I mentioned previously, when it comes to sentencing, the courts won't normally look at this section in isolation, but will look at the sentencing guidelines which are provided from the Sentencing Council, and can access the sentencing guidelines on the Sentencing Council website as well. And they're different depending on whether you're in the Magistrates Court or the Crown Court. So Section 12 is about imposing conditions on public processions, and I've included an asterisk here because this legislation is currently in force at the time of recording, but it is pending amendments. So, and this isn't the whole section but just the key parts, and this will be relevant for the rest of this section on protest. But if the senior police officer, having regard to the time or place at which and the circumstances in which any public procession is being held or is intended to be held, and to its route or proposed route reasonably believes that A. it may result in serious public disorder, serious damage to property, and serious disruption to the life of the community. In the case of a procession in England and Wales, the noise generated by persons taking part in the procession may result in serious disruption to the activities of an organisation which are carried on in the vicinity of the procession. In the case of a procession in England and Wales, the noise generated by persons taking part in the procession may have a relevant impact on persons in the vicinity of the procession, and that impact may be significant, or the purpose of the persons organising it is the intimidation of others with a view to compelling them not to do an act they have a right to do, or to do an act that they have a right not to do. He may give directions imposing on the persons organising or taking part in the procession such conditions as appear to him necessary to prevent such disorder, damage, disruption, impact, or intimidation, including conditions as to the route of the procession or prohibiting it from entering any public place specified in the directions. And so, that is a bit of a mouthful, so to break it down, it is an offence if it may result in serious public disorder, serious damage to property, or serious disruption to the life of the community, and so that may lead to criminal liability if that takes place. And this includes noise generated by persons who are taking part in the procession, which could cause serious disruption. And so if these things are believed to take place, or there's a risk of them to take place, the senior police officer can give directions which may prevent this disorder from taking place and prohibiting various parts of the protest. And if that's not followed, then that will be a criminal offence, as will these actions if that is what goes on. Plus, it's worth mentioning that peaceful protest is allowed and encouraged. Violent or unpeaceful protests are not allowed. But let's have a look at section 13, which is also pending amendment but is currently in force, and this is about prohibiting public processions. So subsection 1 provides that if at any time the chief officer of police reasonably believes that because of particular circumstances existing in any district or part of a district, the powers under Section 12 will not be sufficient to prevent the holding of public processions in that district or part from resulting in serious public disorder. He shall apply to the council of the district for an order prohibiting for such period not exceeding 3 months as may be specified in the application, the holding of all public processions or of any class of public procession so specified in the district or part concerned. So this is essentially saying that if the chief officer of police believes that there is a risk of serious public disorder, he may apply to the council for an order which will prohibit any public processions either in a certain class or in a certain topic, so let's say environmental protests, or public processions altogether for a month which must not go beyond 3 months. And so this is an incentive to not take part in serious public disorder, because that could have an impact on your cause which you are protesting for, as well as the causes of many others. And so, yeah, a notice can be given to prevent any public processions for up to 3 months where there is a risk of serious public disorder. But going on to section 14, which is imposing conditions on public assemblies. And again, this section is a pending amendment. But this provides that subsection 1A applies if the senior police officer, having regard to the time or place at which and the circumstances in which any public assembly is being held or is intended to be held, reasonably believes that A. It may result in serious public disorder, serious damage to property, or serious disruption to the life of the community. And so, this, like the previous legislation, means that there can be steps which take place if there's a belief that there's a risk of serious public disorder, damage to property, or disruption to the life of the community. And in the case of an assembly in England and Wales, the noise generated by persons taking part in the assembly may result in serious disruption to the activities of an organisation which are carried on in the vicinity of the assembly. And in the case of an assembly in England and Wales, the noise generated by persons taking part in the assembly may have a relevant impact on persons in the vicinity of the assembly, and that impact may be significant, or the purpose of the persons organising it is the intimidation of others with a view to compelling them not to do an act they have a right to do, or to do an act they have a right not to do. The senior police officer may give directions imposing on the persons organising or taking part in the assembly. In the case of an assembly in England and Wales, such conditions as appear to the officer necessary to prevent the disorder, damage, disruption, impact or intimidation mentioned in subsection 1. So again, this is very much similar to the previous sections on public processions, where if you do any of the above, cause serious public disorder, damage to property, disrupt the local community, etc., etc., the senior police officer may take steps which they see as necessary to prevent that disorder, damage, or whatnot. But this is slightly different in Scotland, where they have to, under such conditions, as to the place at which the assembly may be or continue to be held, its maximum duration, or the maximum number of persons who may constitute it, as appears to the officer necessary to prevent the disorder, damage, disruption, or intimidation mentioned in subsection 1A or 1B. So they may impose conditions, essentially. Section 14A also looks at prohibiting trespassory assemblies, and again this is pending amendments. But if at any time the chief officer of police reasonably believes that an assembly is intended to be held in a district at a place on land to which the public has no right of access or only a limited right of access, and that the assembly is likely to be held without the permission of the occupier of the land, or to conduct itself in such a way as to exceed the limits of any permission of his or the limits of the public's right of access, and may result in serious disruption to the life of the community, or where the land or a building or monument on it is of historical, architectural, archaeological or scientific importance, in significant damage to the land, building or monument, he may apply to the council of the district for an order prohibiting for a specified period the holding of all trespass assemblies in the district or a part of it as specified. So this brings in some land law. Land is obviously a very important asset under the law of England and Wales, and essentially going onto some private land without permission is trespass. And so this section prohibits any trespass in order for an assembly to take place. So yes, you are allowed protests in terms of public processions and assemblies, but they must not take place on land where you do not have permission to be. But under the law of trespass, if you initially had permission to be on land, but then you exceed that permission by doing something you are not permitted to do. So the classic example is if you've got permission to be in someone's house and to go up their stairs, you've got permission to walk down the stairs, but you do not have permission to slide down their rails. So if you were to slide down their rails, from that point, your lawful entrance would become a trespass because you've exceeded your permission. And so the same applies here. And like the previous sections we've just looked at, if there's a risk that there's going to be trespassory assemblies, then the key authorities can apply to the council to prevent any trespassory assemblies, but all trespassory assemblies either in the district as a whole or in a specific part of it. And so this is just about getting permission and to do these protests legally. And now we're going to go and backtrack a bit to some of the earlier offences under the POA, which would also be criminal offences which would make a protest unlawful and not peaceful. And so let's get straight into it. So section 1 is riot, and this provides that where 12 or more persons who are present together use or threaten unlawful violence for common purpose, and the conduct of them taken together is such as would cause a person of reasonable firmness present at the scene to fear for his personal safety. Each of the persons using unlawful violence for the common purpose is guilty of riot. It is immaterial whether or not the 12 or more use or threaten unlawful violence simultaneously. The common purpose may be inferred from conduct. No person of reasonable firmness need actually be or be likely to be present at the scene. Riot may be committed in private as well as in public places, and a person who is guilty of riot is liable on conviction on indictment to imprisonment for a term not exceeding 10 years or a fine or both. So essentially, with any public gatherings, protests, whatnot, you must not cause anyone to feel in fear of their own personal safety. And this is a person of reasonable firmness, so it doesn't matter if they've got conditions which make them vulnerable, but we're taking the reasonable person of reasonable firmness. And the reasonable person standard is a common test in the law. But most importantly, there needs to be 12 people together who use or threaten violence, but those 12 people don't need to use that violence or that unlawful violence at the same time. It can all be separately. They must also have a common purpose which can be inferred, but the person who may be at fear of his personal safety or her personal safety, they do not actually have to be there. There's not actually have to be anyone there, but if there was someone there and they would fear for their personal safety, that would be an offence under section 1 of the POA. And riot can also be committed in private as well as public places, which some may argue is a bit questionable, but I suppose it makes sense because we're trying to avoid situations where people will be put in fear of their safety. And similarly, section 2 of the POA considers violent disorder, and under this section provides that where 3 or more persons who are present together use or threaten unlawful violence, and the conduct of them taken together is such as would cause a person of reasonable firmness present at the scene to fear for his personal safety. Each of the persons using or threatening unlawful violence is guilty of violent disorder. It is immaterial whether or not the three or more use or threaten unlawful violence simultaneously. No person of reasonable firmness need actually be or be likely to be present at the scene. Violent disorder may be committed in private as well as in public places, and a person guilty of violent disorder is liable on conviction on indictment to imprisonment for a term not exceeding 5 years or a fine or both, or on summary conviction to imprisonment for a term not exceeding 6 months or a fine not exceeding the statutory maximum or both. So this is very much similar to section 1, which covered riot, but it just requires 3 people or more rather than 12, and they need to threaten unlawful violence to one of reasonable firmness. And similarly, they do not have to do the violence at the same time. Nobody actually has to be present, and it can happen in both public and private places are the key points. And this all goes back to peaceful protests. Peaceful protests are allowed. Protests which make people fear for their safety or break the criminal law are not peaceful protests and not allowed, particularly under the Public Order Act of 1986. This is a statute which we are now examining in some detail. The next is the section 4, which is fear or provocation of violence. And so this section provides that a person is guilty of an offence if he uses towards another person threatening, abusive or insulting words or behaviour, or distributes or displays to another person any writing, sign or any other visible representation which is threatening, abusive or insulting, with intent to cause the person to believe that immediate unlawful violence will be used against him or another by any person, or to provoke the immediate use of unlawful violence by that person or another, or whereby that person is likely to believe that such violence will be used or is likely that such violence will be provoked. So this first subsection is related to the common law of assault. Assault just means that there's a fear of immediate violence. Assault does not need physical contact or physical violence. Assault is mainly just a threat or fear of such violence. And so this puts this in statute, particularly for protests. So if someone fears that violence will be used against him or another person, or they try and provoke the immediate use of unlawful violence by that person or another, then that person will be guilty of an offence. And subsection 2 provides that an offence under this section may be committed in a public or a private place, except that no offence is committed whether words or behaviour are used, or the writing, sign or other visible representation is distributed or displayed by a person inside the dwelling, and the other person is also inside that or another dwelling. So yeah, this offence can take place in either public or private, but the key here is that there needs to be immediate use. There's a fear of immediate unlawful violence. So I'll highlight that here. There's a belief that there will be immediate unlawful violence. And so why is this important? If someone is inside displaying a sign, writing or whatnot, which could be seen as causing someone to fear unlawful violence, but the other person is outside, then it's argued that this cannot be immediate, because if one person is inside and the other person is outside, there's distance between them, and so it's highly unlikely there's going to be immediate unlawful violence. You might suggest that maybe, what if someone had a gun or another weapon, firearm, in the building, and they pull it out then and shoot the person? That's surely immediate unlawful violence, and I would suggest so. But that would actually be the conduct, not the fear of. So this is the equivalent to common law assault, where someone fears that violence might happen, but where violence actually happens under the common law, that is battery. And so the previous sections and other sections of the legislation would prosecute someone if they actually did carry out those actions. But anyway, that concludes this part of the lecture, which looks at the law around protesting and what you can and can't do when it comes to protests. So we now move on to what's essentially the last part of the law proper in this lecture, and that's the human rights legislation. And so in England and Wales there are two main pieces of legislation which are important. The first is the Human Rights Act 1998, then the second is the European Convention on Human Rights, ECHR. So the ECHR lists a number of different human rights which people have, providing their state, i.e. their country, are part of the ECHR. And so it's the Human Rights Act 1998 which makes the UK become part of the European Convention. And so it's this legislation which gives the ECHR legal binding on the country. And this is just a matter of international law. In the UK, in England and Wales, the country is not bound by international law unless we make a domestic statute, a statute made in our Houses of Parliament, to give the international law essentially permission to have authority over our domestic law. So Section 1 gives action to the Convention rights. It gives legal binding to the Convention rights. So these are the rights which we as citizens in England and Wales can rely on. And so these are Articles 2 to 12 and 14 of the Convention. Any other articles which are not within those within that section cannot be relied on by individuals in England and Wales. Then Section 3 concerns the interpretation of legislation, and this is really important. Subsection 1 of this section provides that, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. Subsection 2 goes on to mention that this section applies to primary legislation and subordinate legislation whenever enacted, does not affect the validity, continuing operation or enforcement of any incompatible primary legislation, and does not affect the validity, continuing operation or enforcement of any incompatible subordinate legislation, if, disregarding the possibility of revocation, primary legislation prevents removal of the incompatibility. And so what this essentially means is that when you go to court, and if you're going to be sentenced or charged based on a certain part of the statute, then the court must interpret that statute, giving effect to the Human Rights Act and the rights within the ECHR as far as they're able to. So as far as the courts are able to, they must interpret the legislation with regards to the Human Rights Act. However, if they're a part of the legislation which is clearly not compatible with the human rights, it breaches any of the human rights, and the court cannot interpret the legislation in a way which is compatible with the rights, then the court cannot not apply that legislation. They must apply the legislation as it is, and they must sentence an individual based on that legislation. What would happen then is the courts would have to issue a statement of incompatibility to the government, asking them to make it compatible to the ECHR. But that's not a legal requirement. The government do not have to make it compatible with the ECHR. And so, let's say some of the legislation was not compatible with the ECHR, and the government would not change it. You could then go to the European Court of Human Rights to argue that. And whilst I'm on this topic of the Human Rights Act and the European Convention on Human Rights, you'll notice that I've written the Council of Europe. That's because the ECHR is completely separate from the EU, which the UK has now left. The EU is governed by the Council of the European Union, and that's completely separate. The Council of Europe is completely separate to the EU, and they are in charge of the European Convention on Human Rights. When you go to the European Court of Human Rights, it is the Council of Europe who are in charge of that, and the Council of Europe has nothing to do with the EU. And so we are still currently under the ECHR, although the previous Conservative government did make it clear that they weren't a fan of the Human Rights Act 1998 and the ECHR, and they were going to bring in a Bill of Rights, but that's a topic for another lecture altogether. And finally, on this slide, Section 6 provides acts of public authorities. And so that means it is unlawful for public authority to act in a way which is incompatible with a convention right. And this basically means that you can only enforce the ECHR against public authorities. So that's the government, the courts, Home Secretary, Home Department, anyone who has a public capacity. You cannot enforce ECHR against private individuals or private businesses. But anyway, now that we've had a discussion of that, let's go into the areas of the ECHR, the various articles which are particularly relevant for this. Okay, so now let's go into the actual articles relevant to this lecture. So, the first article of the ECHR, which is relevant for us today, is Article 9, and that's the freedom of thought, conscience and religion. And this provides that everyone has the right to freedom of thought, conscience and religion, and this right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in worship, teaching, practice and observance. So this means you're allowed to have a religion, and you've got the freedom to practice that religion however you may wish. And the freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. And so essentially, although you can practice your religion in any way you like, the state are allowed to put in limitations if it's necessary for a democratic society or for the safety of the public or health and morals. And so there are some limitations to this, but essentially one is allowed to have an opinion about different topics, even if they are controversial topics, or there are organisations which were involved in the topic which have been banned. These organisations are often banned due to their actions. So if you were expressing your opinions or thoughts about a matter such as a war, this would not be a crime, and if prosecuted, there would be grounds to sue the state in the European Court of Human Rights. And so, relating this back to the Palestine Action and Palestine protests, you're allowed to campaign and protest about Palestine, but Palestine Action has obviously been prescribed because it's been found that there's public safety risks and it may not protect the rights and freedoms of others potentially. So that's the key law for this bit. And moving on, we have Article 10 of the ECHR, and this is about freedom of expression. It provides that everyone has the right to freedom of expression, and this right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing or broadcasting television or cinema enterprises. So this means that everyone has a right to freedom of expression, and you are allowed to express your opinions in whatever way you like. But then if you are a business or a journalist, broadcasting organisation, whatnot, the state are still allowed to license you, i.e. you're required to be given a permission from the state, which you often need to pay for in order to have that freedom of expression. It goes on to say that the exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are are necessary in a democratic society in the interests of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. So this right has similar limitations as the previous one, but it's also worth mentioning that although you do have the freedom of expression, with that right you do have duties and responsibilities as well. And so there can be restrictions in place if freedom of expression has a risk of interfering with a democratic society, security, or public safety, and so on. So with your opinions and thoughts, you are indeed allowed to share and publish these in either public or private manner, so long as they do not negatively impact any other individual or group or organisation, and it must also not be criminal behaviour. Helping those in need or sharing an opinion online is not a crime, and if convicted there would again be grounds to go to the European Court of Human Rights. So moving on again, Article 11 of the ECHR is the freedom of assembly and association, and this provides that everyone has the right to freedom of peaceful assembly and to freedom of association with others, including the right to form and to join trade unions for the protection of his interests. No restrictions shall be placed on the exercise of these rights other than such as are prescribed by law and are necessary in a democratic society in the interests of national security or public safety, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. This article shall not prevent the imposition of lawful restrictions on the exercise of these rights by members of the armed forces, of the police, or of the administration of the state. So essentially, you have the right to protest and to form peaceful assemblies and to associate with others, unless there are problems with national security or public safety and so on. And so, before Palestine Action would have been prescribed, you would have had the right to associate with them. But since they've been prescribed, this would have been due to issues of national security or public safety. You no longer have that right. But essentially, protests are legal, as we have seen, so long as they are peaceful and do not lead to any criminal behaviour or behaviour which could risk the health and safety of the public. And that's something we've seen in the previous part of this lecture, which looked in detail at the relevant human rights legislation. Which looked at the relevant legislation around protests, particularly the Public Order Act of 1986. Then finally we have Article 14 of the ECHR, and this provides that there is a prohibition of discrimination. So the enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any grounds such as sex, race, colour, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth or other status. So regardless of your religion, political or other opinions, or whether you're a minority, if you are campaigning against an issue, such as the Palestine issue, you cannot be discriminated against that. So let's say, to use an example I was given, if you were Muslim and you were discriminated against and arrested or imprisoned for whatever reason because you were protesting for Palestine, yet your white counterparts, English counterparts, were not interfered with by the police, that's a clear case of discrimination, and that's clearly not allowed. Public authorities such as the state, government, courts and judges cannot discriminate based on these grounds at all. Therefore, if one was sharing an opinion and actively advocating for a specific situation such as war, such an individual could not be prosecuted because of these protected characteristics, and they would indeed be grounds to go to the European Convention on Human Rights. That would be something I would highly recommend as well. Obviously see a legal advisor, barrister or solicitor for that, but it's important that we have these human rights available for us, I would say. And going on a bit further into this law around discrimination, we have the Equality Act 2010. And this is essentially domestic law in England and Wales, and Section 4 provides the following protected characteristics. That's age, disability, gender reassignment, marriage and civil partnership, race, religion or belief, sex, and sexual orientation. And so no one in the UK, in England and Wales, can discriminate anyone else based on these protected characteristics. And if you were discriminated based on any of these characteristics, that is a crime, and the other person can be liable. And so similarly, if you're doing protests or whatnot, you cannot be discriminated even by public authorities on this legislation, but with public authorities, and so well as being protected under this statute, you obviously also have the European Convention on Human Rights you can rely on as well. But anyway, that now concludes the area of law, the law proper, all the legal content we're going to cover. And so now I'm going to have a brief discussion on what is critical analysis to start to conclude this lecture. And this is very much one of the key learning objectives. So critical analysis is often what you need to do both at law school and when you're doing essays and journal articles when it comes to law. And so one part of critical analysis is evaluating the law. So that's seeing whether the law is doing what it's meant to be doing or not. What are the strengths of the law? What are the weaknesses of the law? And here you will be drawing on different opinions. So your own opinion, maybe the opinions of others, and seeing how well the law is fit for its purpose. As well as that, you might see that there are areas of law which either are weaknesses or you disagree, and so you will question that law and you will consider why that law is wrong, drawing on different legal perspectives. So you will look at other academics and other journal articles and other sources, maybe even the law of other countries, see how they do things, then compare it to the law you're analysing, and really see whether the law is fit for purpose, and just keep questioning. And often you will see arguments for reform, especially when it comes to criminal law, and this is something I like to do whenever I am concluding any of my journal articles. Look at ways we can reform the law. How can we make the law better? If the law is not good enough, what's the alternative? Because we need laws in place to maintain order and to keep society under control. And so if you're saying one of the laws is not good enough, propose a new law, reform. What can we do which will be better? If you say the law is good enough, then maybe say why reform is not necessary. And essentially, when it comes to critical analysis, i.e. essay questions, we're more looking at what the law ought to be rather than what the law is. Whereas when it's problem questions, it's very much what the law is rather than what it ought to be. See, it's when it comes to essay questions, you have that freedom to provide your opinion on what you think the law ought to be. And that's a basis of critical analysis. And in the future, I will upload a more fuller, detailed lecture which covers critical analysis in more detail. But I will mention at the end of this lecture how you can practice this critical analysis in relation to the content we've covered today, particularly maybe around the law of proscription and whether the proscription of Palestine Action, your opinion, was just based on legal arguments. So that's what I mean by critical analysis mainly, and that's a key skill for anyone who wants to go on to do a law degree or wants to be a lawyer. So to summarise what we've covered today, I would say you cannot technically be arrested for protesting about the Israel-Palestine conflict or any other conflict unless you are supporting or presenting yourself as a member of Palestine Action or any other proscribed group. We have seen that you are allowed to protest so long as you provide notice, you obey any restrictions, and the protests are peaceful. It's a human right to be able to have an opinion and to advocate that opinion. And under the Equality Act of 2010, you cannot be discriminated against based on any of the protected characteristics. So ultimately, my legal opinion remembering this is not legal advice but purely an opinion, an academic opinion from a law student. I would say that an individual who is supporting a cause publicly or in any other way cannot be charged with an offence under the terrorist legislation unless there is evidence they are either a member or they support a proscribed organisation. But again, I must reiterate, if you require legal advice or would like to be advised on your rights, you must seek formal legal advice from a qualified lawyer with experience in this area. Let's review the learning objectives from this lecture. So we said that we will be able to define what is legally meant by terrorism. So you should remember that it comes from section 1 of the Terrorism Act, and the key parts are damage to either property or risk of safety to others, which is designed to influence the government. Describe the process of proscribing certain organisations, and so it must come under the definition of terrorism. And the Secretary of State must think that there's a risk in it. Remembering it's Secretary of State's opinion. Explain the basic law around protest. So you need to give a written notice to the police. You need to obey any of their instructions, and it must be peaceful. No riots, no violent behaviour, no behaviour which could make people fear for their safety. As well as describe the relevancy of human rights legislation. So you have the right to possess for protests and public assemblies. You have the right to share your opinion, to express your opinion, and you have the right not to be discriminated against. Then, on the practical side, apply the law to both factual and fictional scenarios. We did that at the very start, looking at Palestine Action, the provisional IRA at one stage, and our problem question, where we've been applying the law to those scenarios, and we will critically analyse the law in this area. So I incorporated some critical analysis when looking at Section 3 of the Terrorist Act. Is it really good if it is the Secretary of State's opinion when it comes to prescription, or is this an area of reform? Maybe a committee is needed, and all the committee need to agree that an organisation needs to be prescribed rather than one individual maybe. And we have just looked at what critical analysis is in more detail just a moment ago as well. So hopefully you've managed to achieve all these learning objectives, but if you do have any questions or any thoughts, comments or anything at all, please let me know in the comments section below. But now we come to the end of this lecture, and so to conclude, I reiterate, if you have any questions at all, please do let me know. Use the comment section below. If there's something you found particularly interesting, again use the comment section. If you just want to share your thoughts of this video or literally anything at all, use the comment section below. I will try and respond to as many of the comments as I possibly can. So please do leave a comment, because it's nice to be able to interact with the viewers of my content. Remember to like this video for more videos like this, and also subscribe to my channel for more bite-sized legal information, but also lectures like this, and so you can never miss any content. Finally, independent study. If you have been particularly interested in this area of law and want to explore it further, or you are a law student and need more practice when it comes to problem questions and essay questions, in the description of this video I provided a link to a document which gives you a couple of problem questions and essay questions for you to respond to, and so that will help you practice applying the law and develop your legal writing skills as well as your critical analysis. And if you would like a feedback lecture on these questions, a lecture when I go through the questions which are in the document and go through some of the possible answers, what a good one would look like, and the mark schemes, please let me know in the comment section below, and I will provide a lecture which goes through these questions. If I don't hear anything in the comment section or on the community section of my channel, I will not do any of these lectures for these questions, no feedback lectures, but if there is a demand for it, even if it's just a few people, then I will provide such a feedback lecture to go through those questions. But once again, thank you for listening, and well done if you've made it this far through without pausing or watching the lecture all the way through. And please subscribe and stay updated with more legal content from Law with Charlie. Thank you.